Happy day, I am Ms. Soundarya, Assistant Professor working in Department of Commerce, BCom Accounting and Finance Shift 1 in M.O.P College for Women. So, in this video, the topic that I am going to cover is Indian Contract Act 1872. The contents that I am going to discuss are, first we are going to see a brief introduction about the law, and then we are going to see the introduction about the Indian Contract Act, followed by definition of contract, then essential elements of a valid contract, and finally the classification of various contracts. So, first we will move on to the first topic, which is introduction about the law. Since we are in a modern civilized society, so every other person will be entering into contract with another person. Say for example, if we take landlord, he will be entering into a contract with the tenant. If the government, then it's with the taxpayer, buyer with the seller. So, we will be entering into contract with different parties on a day-to-day basis. So, in order to have a set of conduct and rules to ensure the conformity according to the standards, we will be having the Contract Act 1872. So, the only thing that will undergo a change is the objective before the law. So, it will be criminal law, civil law, industrial law, international law as such. So, in the words of Salman, he has given the definition of law as, law is a body of principle which is recognized and applied by the state in the administration of justice. So, in order to give justice to the people, okay, so not just in the present but also in the future, okay, so the law has been introduced. And the object of law is the order. Okay, so we need to have a set of rules or principles to give as a guideline. Okay, so law does not have a separate definition. It's just according to the perception of the person. So as a citizen of India, I may look law as the set of rules. As a judge, he will be seeing as a set of guidelines for him to give his judgment. Okay, so that is what. So next is the characteristics of law we are going to see, which is law is not said to be static. Okay, so static means it remains the same, but it is not so. According to the societal changes, according to the culture and the principles which is being followed in that particular country, according to the circumstances, okay, so the law will also undergo some changes. And then ignorantia juris is not excusate, meaning that is ignorance of law will not be treated as an excuse. So, as a citizen of a country, we need to know certain set of laws and rules. Okay, so we cannot say that I am not aware of that law, so that I will not be following it. Okay, so ignorance of law cannot be treated as an excuse in any way. Now we are moving on to the introduction of the Indian Contract Act 1872. Okay, so according to the Indian Contract Act, branch of law which determines the circumstances in which promises made by the parties to a contract shall be legally binding them. So when a contract is there, so two parties will be coming into picture in a contract. Okay, so each one will be making a promise, and they will be, automatically the obligation for them will also be created, which will legally bind them to do that particular action which they have promised on. Section 1 to 75, it will deal with the general principles according to the Indian Contract Act, and section 124 to 238 will talk about the special contract acts only. Special contract acts means indemnity, pledge, guarantee, and all that will come under Special Contract Act. And the Indian Contract Act is not considered to be exhaustive. Exhaustive means it's not a complete one, it will not give a complete picture, whereas we have certain other acts which are dealt separately, like Partnership Act, Sale of Goods Act, those and all are dealt separately, whereas Indian Contract Act is not covering those aspects and all. And then the law of contract is not the whole law of agreement, not the whole law of obligation. That is, whatever agreement that is being entered into the Indian Contract Act, it will not automatically give rise to a obligation, whereas whatever legal obligation that is there, that will not necessarily arise from an agreement also. So we cannot completely say that whatever agreement that's being created under Indian Contract Act will lead to an obligation, or whatever obligation that is there, that will necessarily arise from an agreement only under the Indian Contract Act. So there are certain things which is not under the purview. And then it creates just in rem and just in personam. So when we say just in rem means it's a right against a specific thing. Say for example, when I am having a piece of land, so I am possessing it and I can only enjoy the land. So every other general public cannot do it. Okay, so I have right against every other member of the public. So that is called as just in rem. Whereas just in personam means right against a specific person. Say for example, A is a person who is promising to give 30,000 to B. But if A fails to give the money, B can only take action against A and claim it. So that is basically called as just in personam. So right against a specific person. Now we are moving on to the definition of contract. So when I say contract, there are two terms that will come into picture. One is called as an agreement and another one which is enforceable by law. So when an agreement is legally enforced by law, then only it will be treated as a contract. When I say the word agreement, again there are two elements that comes into picture. One is called as the offer and another one is called as the acceptance. Offer means the proposal that is being made by one party, whereas acceptance means it is accepted by another party and the other party must communicate the acceptance to the promisor, that is the person who is giving the offer. So offer and acceptance. So put together that forms an agreement, and when the agreement is getting formed, it should be legally acceptable, so which is enforceable by law, thereby a contract will get created. There comes another word that is called as consensus ad idem. Consensus ad idem means, consensus means when two people accepting on same conditions at the same time, that is termed as a consensus. So consensus means when two parties agree to same terms and conditions in the contract, that is basically called as consensus ad idem. Now we are moving on to the essential elements of a valid contract. So when we treat a contract as a valid contract, these are the following points. There are some certain points which has to be there in order to treat a contract as a valid contract. So first one is called as the offer and acceptance. So as we discussed, offer means a party will be giving a offer, and whereas the other one must accept that offer. So a promise will be made and it will be accepted. So when that is there, always the offer must be definite and the acceptance must be unconditional, and it should be absolute, and it should be communicated to the offerer. So that is the offer and acceptance. And then second one, there should be an intention to create a legal relationship. So when always when a contract is entered, there should be an intention for both the parties to create a legal relationship. So when that is not there, then it will not be treated as a valid contract. But under this, there comes two types of contract. One is called as a social contract and another one is called as a business contract. Whenever there is a business contract, it is assumed that there is going to be an intention for both the parties to create a legal relationship. So that is the basic assumption. Only when the business contract says specifically that there is no intention in the contract itself, then only there won't be any intention to create legal relationship. Otherwise, always the business contracts will have an intention to create legal relationship. But whereas the social contract on the other hand, where a relationship between the family members and all that, that will come under the social contract. But there won't be any intention to create legal relationship. Say for example, a husband is promising that he will be giving to his wife a household allowance of 20,000. If he fails to do so, then law cannot come and question them. So that is called as the social contract or a domestic in nature. So there won't be any intention to create a legal relationship. Then the third one is called as, third element is the lawful consideration. Consideration means it is something in written. So when an offer is made and when that offer is being accepted, always a consideration should be given. Consideration need not be in cash or kind always. It can be an act, that is doing some action, or abstaining or restraining a person from doing an action. That will also be treated as a consideration. So there should be always a consideration for a contract. And then capacities of parties. When I talk about the capacity means both the parties to the contract must be of sound mind and they should not have any disqualification with respect to the Indian Contract Act. And also there should be a major person, they should not be a minor. A minor cannot enter into a contract according to the Indian Contract Act 1872. So both the parties must fulfill all these conditions in order to enter into a valid contract. And next one is the free and genuine consent. Consent means giving an acceptance. The acceptance must always be given by a person as a free consent. There should not be any coercion, there should not be any undue influence and threaten that person and get that acceptance. That should not be there. There should be always free consent, then only it will be legally enforceable by law. And then lawful object should be there. Lawful object means that is the law should not specifically say that these type of contract will become void. So, that should not be there. So, if the law has declared certain types of contract as void, it will never be treated as a valid contract. And then finally, certainty and possibility of performance. Okay, so there should be always a that is whenever a contract is entered into, that contract must always lead to an action. It should not be something where a human being cannot perform at all within the specified time limit. It should be actually a human being should be able to do it. Okay, so that is the certainty or possibility of performance. And finally, the last one is the legal formalities. Whenever a person enter into a contract, they should fulfill certain legal formalities which is stated under Indian Contract Act, which should be done by both the parties. Certain contract will lead to get registered or get the incorporation certificate. Certain formalities will lead to the getting stamped by the respective authorities. So, all those legal formalities must be fulfilled in order to be treated as a valid contract. Now, the last part which we are going to discuss is the classification of contract. So, when I say the classification of contract, it is getting divided into three categories. First one is the according to the validity, second one according to the formation, and third one is the according to the performance. So, according to the validity, we have 5 categories under that. So, first one is the valid contract. When I say valid contract, it will be having all the essential elements under that. And then when we move on to the voidable contract is wherein an agreement is enforceable, is treated as legally enforceable from one party's side, whereas the other party has given his acceptance or consent to that contract only because of undue influence or misrepresentation or threatening, then coercion and all that. So, because of that, if he has given consent, then it will be treated as a voidable contract. There are two other situations which comes under voidable contract. Say for example, if a person is given an offer and he says he has promised the other person that he will be fulfilling the agreement, the contract within a specified time limit. But if that person is not able to perform that contract within the specified time limit, that is the agreed time limit, then that contract will also be treated as a voidable contract. And the other situation is when both the parties enter into a contract and when one person is restraining the other person from doing that or executing that contract, then that will also be treated as a voidable contract. So, when I say voidable contract, one party will be giving a free consent, but the other person will not be having a genuine or free consent, then that is also treated as voidable contract. Then when one person has promised a specified time limit, but within that if he is not able to give or perform the contract, then that will also be treated as voidable contract. And the third situation is when one person is restraining the other person from doing that contract, will also be treated as the voidable contract. And then moving on to the next one is called as the void contract or void agreement. So, there are two terms. First, we are going to see void agreement. Void agreement is something which is not enforceable by law right from the beginning. So, wherein like when we enter into a contract with a minor, then it is right from the beginning that contract is not valid. That will be treated as void agreement. The next one is the void contract. Void contract means initially when the contract is made, it is treated as valid, but later it becomes void. Say for example, if a country is importing from another country, when both the countries entered into a contract, it is treated as a valid contract. Subsequently, a war is breaking out between both importing and the exporting country, then it becomes a void contract. So, void agreement means it is right from the beginning it is not enforceable. Void contract means it is enforceable, valid in the beginning, but later it becomes a void contract. Then the next one that comes under the validity is the illegal agreements. Illegal agreements means the agreement which are of criminal in nature and it is immoral. When it comes to illegal agreement, we will also talk about the collateral agreement, that is collateral contract which is entered into based upon the main agreement. If the main agreement is treated as illegal, the collateral agreement in few cases it will be treated as illegal, in some cases collateral agreement will be treated as a valid one. Then the last one under the validity is the unenforceable contract. Unenforceable contract means those contract which is having some technical defect, meaning the aggrieved party, the party who has suffered the loss, if he may not be given any benefit under it, or if he cannot claim any remedy under that contract, then in that particular case it will be treated as unenforceable contract. Now we are moving on to the second part, that is according to the formation. First one is the express contract. Express contract means which is explicitly expressed. It can be in the word of mouth or it can be in the written form. When it is expressed explicitly, it will be treated as express contract. Whereas implied contract is something whereby action or whatever the course of action that is being followed, if the same thing is observed and it's being followed by another person, then that is called as an implied contract. Third one is called as a quasi-contract. Quasi-contract is something which is not a contract at all, but it will be creating a legal obligation and it will be imposed on the person. So the quasi-contract is something which is it is based on the concept of equity, wherein like the person, say for example, if a person has given his own goods to somebody else to keep in his house, but if the other person is going to treat those goods as his own, then in that particular case it will be treated, it will come under the quasi-contract. That is, one person cannot take the benefit out of the contract at the cost of somebody else's expense. So that is the concept of quasi-contract. Finally, it is the e-commerce contract. E-commerce contract is something when both the parties enter into a contract via internet, it will be treated as an e-commerce contract. Now we are moving on to the third one, that is according to the performance. We have two things, that is, one is executed contract and another one is executory contract. Executed contract means, as the name says, both the parties have already performed their legal obligation towards the contract, means it is called as executed contract. Executory means when both the parties of the contract is yet to perform their obligation, then in that case it will be treated as executory contract. Under executory contract, we have two other categories. One is called as a unilateral and another one is called as a bilateral. Unilateral contract means when that is when both the parties enter into an agreement, one party at the time of formation itself, he will be fulfilling his obligation, whereas only one party is yet to perform his obligation, means that will be treated as unilateral contract. Then bilateral contract means when both the parties are yet to perform, it is treated as bilateral contract. So bilateral and the executory contract goes hand in hand. So these are the concepts, basic concepts that comes under Indian Contract Act. I hope you all have understood the concept. So to make you better, to understand better, so you can attend the case study which I have given, and the answer is given at the end of the video. So you can attend the case study and check the answers. That's about it. Thank you and keep learning.